Welcome back to the Dershow. I had always thought that Independence Day was July 4th, but apparently it's April 2nd, independence from reliance on other governments. And President Trump made a big presentation about reciprocal tariffs and how he went through all the other countries that have high tariffs about American goods, and he's going to not get even. He didn't talk about that, but try to make it better for America. We'll see. Short term, probably inflationary effects and higher prices. Long term, let's hope it works to reduce prices. We'll wait and see. Some developments in Israel. Israel has made good on its promise. It said, unless you return the hostages, and so far Hamas hasn't returned any since the last few weeks. They offered to return one, and then maybe they said four. Israel said at least 10. And Israel said, unless you do it, we're going to do two things. We're going to restart our defensive war to destroy Hamas. And second, we're going to permanently annex territory. This is an idea that I have had for many years now to fight terrorism. And so what they're going to do is increase the boundaries of Israel by, I don't know, maybe a mile or half a mile, and use that area, which was part of Gaza, as a security area, a buffer between Hamas and the and Israel. I think that's a good idea. Yeah, there'll be some people who lose some land, but that's what happens when you start a war against the country. You lose land. Germany started a war; it lost land, and other countries that started wars have lost land. So, if Hamas persists in its wars, and he didn't lose any territory when it started the 48 war, the 67 war, the 73 war, but now it may lose some territory, and that's a good thing. So we'll see what develops there. We'll see what develops with Trump's threats against universities, including Harvard, if it doesn't do something more to prevent anti-Semitism. I have a piece in yesterday's Gatestone, which argues that we all supported when the federal government put economic pressure on Southern schools when they were discriminating against blacks. Every liberal I know and most conservatives I know said, wow, that's great. You should put pressure on universities to stop discrimination. But when the discrimination is against Jews, suddenly the sides change, and the liberals, many who regard Jews as privileged and therefore white and therefore not entitled to any benefits, suddenly are opposed to that. The almost the entire Harvard Law School faculty and much of the rest of the university faculty have written letters in which they condemn the Trump administration for in any way trying to put pressure on universities, as if universities somehow have a right to federal money. No, they don't. Universities are becoming propaganda mills, and there's no reason why taxpayers should pay for courses like those taught by Columbia Middle East Studies departments, which aren't courses at all. So I'm in favor of at least some pressure, some of the times against some universities. And even though I have 70 years association with higher education, I'm not adverse to a series of checks and balances where government checks universities and universities check government. All right, let's turn to today's subject. It's a legal subject. It's a very interesting subject. A judge in New York finally, belatedly, correctly, ruled that President Trump, as the elected executive, has the right to determine that Mayor Adams in New York will not be prosecuted federally. If there were state prosecutions, he couldn't interfere with those and couldn't stop those, and there could be conceivably state prosecutions. The same theories that resulted in federal prosecutions could result in state prosecutions, but I doubt that Letitia James or Alvin Bragg are going to go after the mayor. But you never know. But at the moment, the matter is resolved. The judge ruled correctly that the prosecution can be dropped by the president, but that the president couldn't hold it over the mayor's head. What he said is, if you can hold it over the mayor's head, then it's a quid pro quo, as if the entire system of plea bargaining wasn't quid pro quo. Every prosecutor's office is engaged in quid pro quo plea bargaining every day. Unless you wear a wire, we're going to prosecute you. But if you're willing to wear a wire, we won't prosecute you. If you plead guilty, we'll reduce the sentence. But if you don't plead guilty, we'll increase the sentence. Those aren't quid pro quos. What are they? Of course, they're quid pro quos. I would say 90% of the job of a prosecutor is to create quid pro quos. That's what they do. They rarely take cases to trial. When they do, they win almost automatically. Fortunately, there are appellate lawyers like me who sometimes get the reverse. But quid pro quo is the name of the game. So the judge was correct in his result. I don't think he was particularly correct in his reasoning. I think it was an easy case because under our Constitution, the federal judiciary includes federal judges. Federal judges have jurisdiction only over cases and controversies. What does that mean? A controversy in a case means that there are two sides that disagree. Here, in the Adams case, the two sides agreed. Adams' lawyers wanted the charges dismissed, and the prosecution, President Trump, appointed prosecutors, wanted the cases dismissed. The only people who didn't were the U.S. attorneys, but they have to take orders from Main Justice in Washington. And my friend and former research assistant, Danielle Sassoon, decided she couldn't accept that order. That was within her moral rights, and she resigned from being the acting U.S. attorney. And she was a great assistant U.S. attorney, would have been a great U.S. attorney, but she did not think it was the right thing for the president to exercise his power. She didn't say he didn't have the power to do it. She just thought his exercise of power was inconsistent with her morality, and that's her right. And one of the great rights that all Americans have when you're in the government is to resign and protest. So she did that, and all credit to her for doing that. And I think she's emerged from this thing very well. Her principles intact. She's now home taking care of her new baby. And we've lost a great potential U.S. attorney, great potential prosecutor, but she'll land on her feet. She'll get a good job. I know she's already been offered jobs, probably in law firms and teaching positions and other jobs. She'll emerge as something of a hero. There's another case now pending in California where another friend of mine, a very, very good prosecutor, was fired while prosecuting somebody else. And that case may go to litigation eventually. We don't know. And or at least to some kind of administrative hearings. But there's no question that President Trump is pushing the limits of his power to the point where it conflicts with what judges think may be their power or what line prosecutors think may be their power. That's not a constitutional crisis because there's a way of resolving it. The way of resolving it is the president gets to decide executive decisions. And if you don't like it, you can take it to court. You can argue with it, you can protest, you can resign, and the president has to do it in a proper manner pursuant to statutes. Some of them require notice, some of them require due process, some of them require reasons. But in general, a president can fire a prosecutor if the president doesn't like the prosecutor. And of course, whenever a president's elected, they immediately fire or produce the resignation of all the U.S. attorneys. It's very rare that a U.S. attorney is held over from one administration to the other because everybody recognizes that the job of the U.S. attorney is, although obviously prosecutorial, it's also political. And why is it political? Because administrations have different priorities as to who they will prosecute, not necessarily which people they will prosecute, but which categories of crimes they'll give priorities to. As I've mentioned over and over again, the Bible, the book of Deuteronomy, instructs judges and prosecutors, lo takir ponim, do not recognize faces. Do not prosecute people because of who they are, what party they belong to, what race they are, what gender they are, who they voted for, what they've said about people. No, only prosecute them based on the law and the facts of the case. But we also know that the blindfold is often taken off. The real statutes of justice, by which I mean those who actually administer justice rather than the statues that stand outside the courtrooms with their blindfolds on. So the reality is, of course, presidents have the power, and the question often is, have they exercised that power properly? I don't know enough about the Adams case to know whether or not the Adams prosecution was a legitimate one to begin with. I know both of his lawyers, who are both excellent lawyers. One of my former student, the other my lawyer. So I'm very close to the legal defense team of Mayor Adams, and of course they've never thought that this was a prosecutable case, a real case. They always thought it was a politicized case. But many people disagree, and others think even if it wasn't a good case, it shouldn't have been dismissed based on the quid pro quo of you come and help me enforce my immigration policy, and I'll let you off the hook. That's clear because the president and his attorney general and his assistant attorney generals and everybody else basically sent a message that the reason dropping the prosecution is to free the mayor up. More important job of making sure that New York City doesn't, in effect, become a sanctuary city. Because sanctuary cities are, of course, unconstitutional under the Supremacy Clause. You can't have a sanctuary state or sanctuary city. You can't have any region of the United States that doesn't comply with federal law, and federal law includes immigration law and deportation law. Now, there is a constitutional doctrine as well that says the federal government cannot compel state officials to do their work for them. So the line is that the feds can't tell prosecutors in the state, you have to help us round up all these deportable people, but you can't get in the way and prevent them being deported. You can't be a literal sanctuary city. You can't give them sanctuary, though you don't have an obligation to cooperate in the effort to try to get them deported. It's a neat line, but it's an important line. If I were the judge, I would have rendered this decision within an hour of being told that the Justice Department wants to drop it, and I would have done it in a one-paragraph opinion without any aggravation, without any input from either side. I would have said there's no case in controversy. Both sides, there are only two sides. The prosecution is represented by the Justice Department, and the defense, as represented by his lawyer, both want the prosecution dropped. I'm out of the case. I have no jurisdiction. I don't even have to rule. The prosecution is dropped. The prosecutor dropped it. That's the end of the matter. I can't resurrect it. I'm not a super prosecutor. That's what the judge should have decided. Instead, the judge went through the whole rigmarole. He appointed a brilliant lawyer to be his advisor on this. The brilliant lawyer wrote a brief saying basically what I'm saying, and the judge ruled that way, but it took, I don't know what, more than a month. Wasted time, wasted effort, and there's no real issue there. So the judge was right. The judge was also right in saying no, this was a tougher one. This is a tougher one. The prosecution did have a disagreement, a narrow disagreement. Both the prosecutor, the Justice Department, and the defense agreed the case should be dismissed. But the defense wanted it dismissed with prejudice, without any possibility of being restored. And the Justice Department wanted it dismissed without prejudice. So that is a case in controversy. I take it back. That part of it is a case in controversy. And the judge had to decide that. I think they decided it wrongly, although he's right that you don't want to have prosecutors holding things over mayors as a matter of policy. I think as a matter of constitutional law, I don't see the basis. He's not, after all, he doesn't have a roaming delegation to do justice. If the prosecution wants the case dismissed without prejudice, that's the way it gets done. I don't think the judge really has a role to play. He might have a role a year down the line or 2 years down the line if the prosecutor then comes back and says, it was without prejudice, so we're going to go prosecute him. If the judge then feels that the prosecution was improper based on an improper quid pro quo, then I imagine the judge would have a role. It's an interesting case. Again, a case I would have taught were I teaching criminal law, criminal procedure at Harvard Law School, as I did over the past 50 previous years. And anything that's interesting enough to teach the law students is interesting enough to put on my show. I had one rule when I taught classes at Harvard Law School, and not every student appreciated this. I said, I will never spend 1 minute in class on an issue that you can look up in a book. If you can look it up in a book, you don't need me. You don't have to pay this enormous amount of tuition to have me repeat what you could easily learn from a book, or if I were teaching today, learn from Google. So everything I'm going to teach you in this class, you can't learn in books. You can't learn in books. It grows out of experience. It grows out of practice. It grows out of theoretical arguments that I've thought about for a long time. But my job is not simply to repeat what's in a book. And so these are the kinds of issues that are not in books. You can't look up this judge's opinion in the Adams case. You can't look that up. You have to think about it. You have to consider both sides. You have to weigh the arguments. And then you have to come to a conclusion. Yes, based on what's in books, but the answer is not given to you by the books. The answer is given to you by today, real intelligence. Maybe in 50 years, you'll be able to put all the facts in a machine and get an artificial intelligence answer that may be just as good as the answer a judge will give you, certainly the way today's judges operate. I prefer a lot of artificial intelligence to the real lack of intelligence that many judicial decisions reflect today. But that's just my opinion, maybe my bias over a long period of time. Interacting with judges, one of the reasons I never wanted to be a judge is I didn't want to be involved in that process. Another was a little bit egotistical. If I'm going to be involved in basketball, I'd rather be Larry Bird or Magic Johnson rather than the umpire. The joke, they say that when a Jewish kid becomes bar mitzvah, he learns that his chances of playing in the NBA are slightly less than his chances of owning an NBA team. Basketball was, of course, created in the 20th century largely by Jews. The first NBA franchises were almost all owned by Jews. The Philadelphia Spas was one of the first teams. What do you think Spas stood for? South Philadelphia Hebrew Association. That was the team. And many of the other teams, obviously Red Auerbach was one of the founders of basketball, also went to my mother's high school in Brooklyn. And so, there is a very deep connection between Jews and basketball, more so than other sports like baseball or football. And, basketball was a city sport. And, I lived in a little house. We had a hoop in the backyard. It was made out of an old ping pong table. And we found in a junk shop a hoop, put up the hoop, and that's where I developed my jump shot. And unfortunately, the rim was only 9 3/4 feet high. So when I got to play in Madison Square Garden and other places, my jump shot fell a little bit short. But that's just a little biography. By the way, some people have asked me, if you look over my shoulder, you see, I think I'm pointing at it now, a picture of Franz Kafka, the great writer from Czechoslovakia who wrote The Trial on America. A lot of letters have said, why do you have a picture of Luigi Mangione on your wall? It's not Luigi Mangione. I'm not putting his picture up. I wouldn't vote for a law named after Luigi Mangione. He may bear a slight resemblance to him, but he's Franz Kafka, one of the greatest writers of the 20th century. Talk about thinking and talking about being having advanced knowledge of what would happen. You read The Trial, and then you look at what's happened to law in America, and you say, he wasn't writing fiction. He was writing a prediction of what was going to happen in many, many parts of the world. So that's Franz Kafka, not Luigi Mangione. But thank you for noticing it. Okay, let's go to some letters. This is a good one. If someone is acquitted in a state trial and then the federal government files charges, is this double jeopardy? I think it is, but Justice Brennan didn't. And he wrote a decision for the United States Supreme Court saying that the federal government does have the power to try somebody for identical conduct for which he was acquitted in the state court. I don't think that's fair. And I don't think it's what the framers intended, but that's what the Supreme Court, per liberal justice, has ruled. And that's the law. By the way, that law is not binding on the states. So that, for example, if Mangione is acquitted in a federal trial for shooting this guy, and then the state comes and tries him for exactly the same charges under New York law, not under federal law, it is double jeopardy. So New York law is more protective than federal laws when it comes to double jeopardy. But it's a great question. It's the kind of question I might ask on a criminal law exam. And the answer for me would not depend on what the law is, but on an analysis of the policies behind the law and what it should be. Okay. Can Mangione, if convicted for life, get a presidential pardon from the next Democratic president? Yes, he can. Yes, if it's a federal case and if he's or even if he's sentenced to death, because it would take more than 4 years for the death penalty to be imposed. And I think it's very likely, for example, if he does get the death penalty, and if somehow he can delay the execution and somehow in 4 years, liberal Democrats elected, he might very well commute the death sentence the way Joe Biden commuted several death sentences, which were obtained under Republican administrations. This is interesting. I watched a clip of you talking on a panel in 1973. What are we talking now? 52 years ago, talking about the prospects of an impeachment and trial of Nixon. Your views then seem pretty consistent with what you expressed today. Thank you, Professor. As I've told you before, I am boringly consistent. I rarely change my mind. I certainly don't change my mind based on partisanship or who's in office. I don't recognize faces. I take very seriously the biblical command. So it's not surprising that I had the same view on the impeachment of Nixon. Clinton, if there had been an impeachment against Biden, I would have the same view. I'm not sure about the 25th Amendment, but yes, under impeachment, and the same view for Trump. Boringly consistent. This is a good one. I've never understood the whole concern about dual loyalties. Loyalties, if you're Jewish, are you loyal to Israel, loyal to America? I said I turned down an offer to be the Israeli chief representative of the United Nations because I didn't want a conflict of interest in case the United States and Israel ever differ on policy, as it did, for example, under the Biden administration, and even more so under the Obama administration. I never understood the whole concern about dual loyalties. He says, I'm Irish Catholic. I support Israel. I care what happens in Ireland, just like Alan cares about what happens in Israel. I still have loyalty to Ireland. I am proud of my heritage, just like every Jew I know is proud of Israel. What's wrong with having loyalties to both nations? Of course, you can take it further. If you're an Italian Catholic and you're very religious, you have a loyalty to the Pope. Remember when John Kennedy ran, people said, oh, dual loyalty, he's going to do what the Pope wants him to do. And he had to make a special speech saying, no, if I'm president of the United States, I will do what the Constitution. The only person who's ever had that kind of conflict was Justice Scalia. He did say that he puts his loyalty to the Catholic Church, to the Vatican, to the Pope, above his loyalty to America. His loyalty to God transcends his loyalty to any particular country. He, however, said he had never been in a situation where there was a conflict between his loyalty to the Catholic Church. There were situations where the church advised against certain things like capital punishment, but it was not a part of the doctrine, the official doctrine. It's not a venial sin to support the death penalty. So it was not. But he did say if he might have experienced that in cases of abortion, but the Supreme Court didn't deal with abortion on a retail basis. It only dealt with it on a wholesale abstract basis. I was never particularly convinced by Justice Scalia's argument. In fact, I wrote about it in an article in a magazine called First Principles, I think. And we debated back and forth, and we debated in person back and forth as well. But rarely is there a situation where there's a really direct conflict between the Catholic faith or the Protestant faith or the Jewish faith and the United States government. Next letter. Many suggested Donald Trump be on the ticket, and we're talking about 4 years from now, 3.5 years from now, as vice president. Then the elected president steps down and the VP takes over. Hence, Donald Trump's new term as VP, elevated to acting president. Cannot happen. Cannot happen because under the 12th Amendment, in order to be a candidate for vice president, you have to be eligible to be the president. And at least under my interpretation of the 22nd Amendment, you're not eligible to be president, even though it only says elected. I do not believe this ploy would ever work, nor do I believe that Vance would agree to be elected president and then step down. So it's an interesting hypothetical and, good for barroom talk or conversation, but it's not real. Okay. Legendary songwriter Irving Berlin was inspired to write the words of the unofficial anthem of the United States, God Bless America, by his mom, a Jewish immigrant from Russia. She was constantly humming these words in gratitude and love. God bless America. My mother and my grandmother also, God bless America. And there's a great cantor, Jewish singer named Sholem Lemmer. He's actually like a second cousin of mine, who has sung God Bless America, both in English and in Yiddish. And he sung it not in Fenway Park. I'm trying to get him to do it in Fenway Park. He's done it, I think, in Madison Square Garden. I think he's done it for the Yankees, and I think he's done it for the Mets. Got the bench, America. And he sings it in Yiddish. It's very nice. Okay. I talked about Mangione first offense, and maybe a jury won't give him the death penalty. Somebody writes back an absurd analogy, but I'll read it to you. Ted Bundy was young and had no prior record. First, he wasn't that young. Second of all, he didn't have a prior record because he hadn't been caught, but he killed numerous people. So there's a big difference between Ted Bundy, who was a serial killer. And by the way, one reason he was a, quote, successful serial killer is he didn't look like a serial killer. He was pretty good looking and looked like a nice guy and was able to lure women, tragically, to their deaths. And so, I used to give my students a picture, I have it hanging, of a man, looks like an accountant, very well dressed. And I would ask the students, what do you think he did for a living? And people would, any answer from an accountant to a lawyer, to a politician, to a minister, etc. And it turned out he was the murderer of President Garfield, and was about to be executed. And he decided to have one more formal picture, all dressed up, before he was hanged. And nobody could believe that this was a killer. This was a man who premeditatedly decided to kill the president of the United States. And the point I used to make with that picture is that you can't tell who a criminal is. Lombroso, who talked about, the criminal head and all that, or others who have tried to predict who can be criminals. You can't do it. Prediction is very difficult, which leads me to my final statement. My new book will be out soon. My final major book, my most scholarly book, my magnum opus, is called The Preventive State, Balancing the Threat of Cataclysmic Harms Against Dangers to Liberty. And that's all about prediction. It's all about how we balance our desire to step in and stop crimes before they occur, like by deporting people, against the civil liberties issues. So if you want to advance order it, I got my first copy in the mail today. But you can advance order it on Amazon, and it'll be mailed to you in a couple of weeks. It's my best book, my most important book, the book I hope to be remembered for. And I hope those of you who are interested in my take will advance order it and buy it. So Thank you. This has been a big year for me for books. I've written basically 4 books in a year. The War Against the Jews, The 10 Big Lies, Palestinianism, and now The Preventive State. Not bad for an 86-year-old. 4 books in a year. Okay. We'll see how many I do next year. See you next week.